Case was finished.
Thank you. Mr. Curtin, can I draw your attention to tab 13, which will come up on the screen? This document was the initial publication of the Archdiocese of the Melbourne response. Have you seen that document before?
I can't recall seeing it before.
Perhaps if we can have page 7, which is 0015 on the screen. Now, if we just stop there, do you see paragraph 4.9 refers to the panel will determine guidelines appropriate to the method in which it is to operate?
Yes.
Now, that's the compensation panel. When you took over from then Ms Crennan, did she provide you with guidelines that that panel had determined?
There were no written guidelines and I don't believe any formal guidelines, but she discussed with me the way in which the panel operated and said that in her experience it had worked well, and I discussed it with the other panel members and they were of the same view, so we continued to do that.
So I take it there are no written guidelines published or otherwise? Thank you. Now, just turning to tab 24 in this bundle. This is, again, going back in time, Mr Curtin. This is a fax from Mr Chernoff to Cause in April 1997, and this is in relation to ongoing discussions as to how the panel might work. And if we can turn to the second page, do you see there at the top, the author agrees with the reservation that the lawyers had that somebody from Cause remaining in the room while the panel discusses matters with the applicant. And his concerns are he had about not having an independent person present when discussions ensue was still alive. Nevertheless, he agreed that someone from Cause at the relevant time may create even a greater problem than the one he was apprehensive about. Do you see that?
Yes, I do.
Now, firstly, in relation to having some independent person present in the room, has that ever been a concern of yours?
The only independent people have been people who were support people for the victim. There's never been any other person in the room apart from the victim and the panel.
And has it been a concern of yours to have an independent, that is not a support person of the complainant, present?
A person other than a support person for the victim? Yeah. No.
You record the proceedings, as it were, do you?
No, we don't.
The record you keep are the records that each of you might make during the course of the panel proceeding?
We don't do that either. I note the amount we agree upon, and I note any specific requests, such as a victim may request that he or she not receive a letter from the Archbishop, a letter of apology, or because the default position is that the victim does receive one. So I ask because some victims have expressed a desire not to receive one. And sometimes a victim will ask if he or she can meet with the Archbishop or someone from the Archdiocese, and I note that and put it in the letter I write to Cause, which advises of the amount that's to be offered to the victim. So there are special conditions. There might be other things too. For example, a victim may not wish a letter to go to his or her home address, and I note those things, but they're the only records kept of the proceedings. And they're aide memoirs for me, aide memoir.
And you indicated earlier that on no occasion while you have been chair of the panel has a solicitor from Cause been present?
Absolutely not.
And if there was a solicitor present, that, independent of the panel, that person would be the chosen person of the complainant to attend with them?
The only people who come apart from the victim and the panel are people the victim wants in there and brings with him or her.
Now, in terms of the panel, what are the backgrounds of the current panel members?
One is a solicitor, One is a psychiatrist and one is a retired pharmacist.
And each of them has been on the panel for some significant period of time?
Longer than I have.
Yes.
And there are 2 men and 2 women, and not all of them are Catholic.
Now, just coming back to the record keeping as you've described, what records are kept. In order to ensure some sort of fairness or equity between payments, do you keep any records as to the amounts recommended and the circumstances of the individuals?
No.
Is that a deliberate decision?
I don't think so. I've never seen the need to do it. Mm-hmm. We treat each victim on the merits of the case, and we, as I have said before, our default position in relation to penetrative sex or serious consequences is the maximum or close to it, and we can work within those parameters effectively or being reasonably experienced without writing things down.
Now, Mr Leader gave evidence that it was his recollection that Mr Chernoff, as he then was when he was chair, kept a record or intended to keep a record of each recommendation. I take it that Ms Crennan, as she then was, did convey to you that that was her practice?
I don't recall whether she did or not, but I've never done that except to dictate a letter the following morning with the amount in it, so that and those records are maintained so that if I wanted to remind myself of what someone was offered, I would have the capacity to do that.
Now, just turning to paragraph 48 of your statement, you refer there to assess the effects of the abuse on the victim. The panel considers the medical advice, the personal history, any submissions and any statement that the victim or support person has made. Just stopping there, in terms of submissions, do you mean submissions by the complainant or their representative about their circumstances?
Yes, I do, but sometimes a solicitor will come and make submissions, and we listen to those too.
And then in paragraph 49, you say in reaching a decision, the panel balances these considerations and is informed by the many previous decisions it has made.
Yes.
Now, you said that you don't keep a record of those, so is it the case that being informed by previous decisions is based on recollection and corporate memory?
It's more than that. If we need to refer to previous decisions, we can, but usually we're confident enough about the previous decisions and their accuracy to not refer to them. And one of the reasons is that if there's a particular episode of abuse, there might be 2 members of the same family or 2 people, let's say 2 boys in the same parish, where one says, I'm making a claim, were you abused too? So we know sometimes that there are parallels between circumstances, and we take those things into account.
So has it occurred that you have gone back to the Archdiocese to say, can we have our file back in respect of X because of parallels concerning a current complainant?
Can I say I think so, but I'm not sure. But one of the members of the panel in particular has an excellent memory and can really go to these things with much more confidence than I can.
Now, are you satisfied that the system you have in place, as you've described it, ensures that there is a proper parity with payments to the extent one can give an individual effects?
We do the best we can, and I think we do a good job in that regard. I can't say it's perfect, and I'm sure that victims may have a different view, some of them, but we act absolutely as fairly to the victims as we can.
As you're sitting here today, can you conceive of a better system which would ensure that the panel was informed rather than just based on recollection? And I don't doubt that the panel member has a good recollection.
Well, we could always keep a detailed summary of each case, but that would not overcome the impressions by people of the individuals. I'm sure you know as a lawyer these things are developed and become second nature to people who have to assess things. I'm sure that we could set down protocols and record these things in detail. I'm not sure it would achieve any better outcome or any, I suppose you could say there'd be more patency.
Can you see any disadvantage of keeping such a record?
Well, I suppose the more records you accumulate these days, the more vulnerable they are.
Or compellable?
Appellable, did you say?
Compellable.
Oh, compellable, yes, that's right. If you look at the way in which this compensation panel and the redress system of which it forms part was developed, it's meant to be informal. It's not meant to have the rigour of precedent as a court does, and common lawyers like me are slaves too. But as I say, I think it might be more patent, but I'm not sure it'd be any better.
Have you given consideration to providing reasons to complainants as to how you've arrived at the recommendation?
No.
It's not something you've considered at all?
I have never well, I've thought about the possibility of doing it, but I've never considered it seriously as a desirable thing.
Why do you think it's not desirable?
Because I think it would inevitably cause further angst to the victim. I said compensation is enough for victims, and if you say, well, we thought that you suffered some psychological abuse but it wasn't too bad before we gave you $50,000 as opposed to 75, I think that would be insulting to them. And I think that if you accept that this system is not intended to be full compensation but a financial recognition, then to give long reasons or to give detailed reasons would be counterproductive. And can I say this, we tend to focus a bit on the people who are unhappy with the system. There are many people who are very happy with the system and express their gratitude for us doing our job. I'm not seeking any accolades for it, but we try to treat them with respect and we try to explain the system to us. And many of them say, even during the hearing, how much they appreciate that. Indeed, there was one person who I thought was going to be extremely difficult because this person had corresponded with me at great length before the hearing with many demands, and at the hearing this person said, you know, I had no idea it was going to be like this. You should televise this so people really understand what's going on. And I explained to this person that most victims didn't want to have it televised, but it was a salutary understanding by him of the fact that we were really trying to help him rather than cause him further grief.
Isn't it inevitable if a person gets lower than the capped amount that they're going to feel an insult such as you're seeking to avoid by reasons?
Well, you'd think that, but it's not the case. In fact, many of them express no interest in the money at all. They're very interested in the counselling. some are extremely interested in an apology and some are extremely interested in not having an apology. But I must say, because in damages case we deal in money and therefore we always try and get the most for our clients, it's surprising how few people express unhappiness at it. There are people who do, there's no doubt about it, but they're in a minority.
Now, just coming back to your statement, at paragraph 39, you refer to your practice at a hearing, and in subparagraph B, you advise the victim that the hearing is confidential, by which you mean that anything said will be kept confidential by the panel and that no member of the panel will discuss it outside the room or with anyone else. And then in C, you advise the victim that such confidentiality doesn't apply to him or her, and you usually say that he or she is free to shout it from the rooftops. Now, I think it's been drawn to your attention the application that is made by complainants and ordinarily made at Mr O'Callaghan or Mr Gleeson's stage of the process. That's right?
Yes.
But you would inevitably get a copy of that application
Yes.
with your bundle. Perhaps we can just have 271 on the screen. This is AFA's application, so an application made in February this year. Now, if we can just scroll down to the end of the second page. There's reference in paragraph 7 to if the recommended amount is not acceptable, the applicant may pursue other remedies but can't rely on what occurred at the panel and has to keep what happened at the panel confidential. Do you see that?
That's one way of reading it. If you were construing it contra proferentum, you might not necessarily construe it that way.
Beg your pardon?
It might mean that those on the panel will keep it confidential. It doesn't specifically impose confidentiality on the victim, but
So-
it's capable of that reading.
Well, it's ambiguous if that's the case, isn't it? If it's capable of two readings, that's not desirable, is it?
No, and it's indeed. If that's what, if it's suggesting that the victim has to keep it confidential, I go to some trouble to make it clear to the victim that that's not the case.
Was it your view prior to preparing to give evidence here that that paragraph numbered 7 was ambiguous?
I hadn't paid any attention to it, to be frank.
So I take it that that wouldn't have been part of what you told people.
I mentioned it because, as I say in my statement, some people have said that the system is buying the silence of the victim, and I make it clear to them that they are under no obligations to remain silent.
Now, just turning to the next page, if we can just scroll down to paragraph D, and this is something that's signed by the complainant, you understand that?
Yes?
Neither I nor any person acting on my behalf or any member of the panel or the Archbishop or anyone acting on behalf of the Archbishop or the Archdiocese will, save as required by law, disclose, firstly, to any person any communication, statement or information, whether oral or documentary, made or provided in the course of or in relation to the panel's deliberations. Now, do you read that as imposing a limit upon what a complainant might say in respect of what happened at the panel?
Yes, it's capable of that construction.
Is it capable of any other construction, Mr Curtin?
Probably not.
And then secondly, rely or seek to rely in any proceedings, such communications.
Yep.
And then F, I and each member of the panel and the Archbishop and his advisers will, again, unless compelled by law, preserve total confidentiality in relation to all matters arising in the course of or in relation to the panel's deliberations, whether documentary or oral, or that may be provided to the panel or to me.
Yes.
Now, do you read that as restricting a complainant in respect of what they might say after a panel's deliberations?
Again, it's probably got that meaning. The thing about it is, if it's signed by the claimant, it purports to bind the Archbishop and others as well. And that's a difficult philosophical concept.
Is it your view that this document, at odds with what you understand is the intention of the panel and what the complainant should be able to say after its deliberations, assuming
Yes.
it accepts the offer for the moment?
Certainly, and I think it's long overdue for revision.
And in your mind, who's responsible for revising it under the Melbourne response?
The Archdiocese through their lawyers.
Now, is there any process of review following a decision made by the panel, Mr Curtin?
No. From time to time, a victim will provide fresh information. There have been times when a victim, and this is no criticism of the victim, but will not fully disclose the extent of the abuse to the independent commissioner, to a psychiatrist, to other people, and even to the panel. Sadly, some of that's because of a feeling of guilt or shame, and eventually they are emboldened to tell the truth. In circumstances such as that, we invite them to make either a fresh application or to revisit the application. I have had one occasion where a victim told us something quite different from what that victim told the independent commissioner. I felt that we were bound by the finding of the independent commissioner as to the abuse, and so I asked that person to, I said we can go on the findings that the independent commissioner made, but I think your interests would be best served by discontinuing this process now and going back to the independent commissioner. And the victim was prepared to do that. I told the victim that it would, of necessity, protract the process because of that, but in fairness to the victim, I thought it should be done. But if a victim, I'm sorry to keep going, but if a victim is unhappy with the amount, there's no capacity for review on that basis alone.
Just going back to your first example, do you think it would be desirable in a system going forward for there to be sufficient flexibility for the victim not to have to go back and start again, as it were, but that the panel or the person in the position of determining the amount of redress had the flexibility to take that into account?
No, I think it would be to confuse the roles of the panel and the independent commissioner.
Assuming that any redress system separated those roles?
Yes, if you start again, then you may give some flexibility, but at the way the system is currently designed, that's not possible. And can I say, it has not happened more than twice, and it may have only happened once in the 10 years I've been doing it. So you might be overreacting to, I'm not criticising you, of course, in asking that question, but it might be an overreaction to a very rare event.
Now, in what circumstances do you give advice or information to complainants about whether they should seek legal advice?
If they ask me if they can bring a lawyer along, I tell them they're welcome to do that. Often they don't ask, but bring a lawyer along, and sometimes there's one or two lawyers who regularly come with victims, and they do me the courtesy of telling me they're coming. In relation to me volunteering the question of legal advice, I don't do that. But if people ask me whether they should get legal advice, I would tell them they're welcome to do that.
Who pays for the lawyers who come along with the complainants?
The victims do. And that's made clear. Now, as I say, there's our regulars, if you like, the lawyers, and they're very well familiar with the system, and I don't bother telling them because in one lawyer in particular who regularly comes, I know that that lawyer would tell the victims that beforehand. We've had the discussion in front of the victim many years ago, and now it doesn't need to be said.
Now, are you aware that the Towards Healing protocol either does now or at some stage provided that the relevant church authority would fund a lawyer to advise the complainant as to and prior to signing a deed of release?
No.
Now, in relation to the Melbourne response, do you say or do anything in particular with complainants in relation to a deed of release needing to be signed if they ultimately accept the offer of the Archdiocese?
Well, I tell them that they will receive an offer, that nothing we say is intended to suggest they accept or reject that offer. That's a matter for them and their advisors. But if they do decide to accept it, they'll be asked to sign a release. Sometimes, but rarely, that triggers a further conversation. But unless it's raised further, I say nothing.
And if it is raised further?
I answer the questions that I'm asked honestly and as best I can.
And that has occurred?
Yes.
Tell us about the circumstances of it having occurred.
Well, they say, sometimes they might say, can I get legal advice about it? And I say yes. And now, if you're unsure about it, you should seek advice.
Have there been circumstances where you've advised somebody not to seek legal advice in respect of a deed of release?
Never.
Now, you'll be aware that there was some discussion on a recent Four Corners in respect of that matter. What can you tell us about that, Mr Curtin?
Well, first of all, even though the victim was identified, I don't propose to breach the undertaking of confidentiality I've given to that victim, but there was a tape recording made of the conversations that the panel had with the victim. That conversation was, as I recall it, in respect of the church providing a lawyer for the purpose of, if you like, attacking the deed of release prepared by the church's lawyers. And I was trying to make it clear that I could not see the point in doing that. It was not intending to dissuade the victim at all from seeking independent legal advice, and I think it's fair to say that that was one grab from which it was clear that there'd been a deal of correspondence beforehand which didn't form part of the program.
Two things. Firstly, you say that the scheme operates so that if a person seeks to have the assistance of a lawyer, they have to pay for the lawyer themselves.
That's right, Your Honour.
That seems at odds with a redress scheme which is advanced as generous and endeavouring to deal fairly and properly with the person. Many people in the community, whether they need to or not, seek the comfort of a lawyer to help them through a process such as this. Do you think it's fair that they have to bear that burden?
Your Honour, I can understand that point of view completely.
Yeah. And secondly, when you come to the question of a release, you and I understand well what a release does and how it operates, but I'm sure you appreciate that many, many people would be daunted by a legal document presented to them in these circumstances, and again, whether they need it or not, would like to have their own lawyer assist them in the matter. Is that right?
I can understand that too, Your Honour.
And does the church, in those circumstances, offer to pay for that lawyer?
As far as I understand, it doesn't. There might be circumstances where the church has. For example, if I was dealing with someone I thought may not, for one reason or another, comprehend what was being transacted at the panel, let alone the impact of a release, I would probably take some steps to do that. To this stage, that hasn't happened. But I readily understand that people should have a lawyer if they're not understanding things, and I can understand also the argument validly being put that it's reasonable to expect the church to provide that in certain circumstances.
Now, you've said that in all the cases you've considered, you don't believe there was a capacity for common law recovery.
That's right.
Now, given that the church's offer is redress, generous and so on as we've discussed, then if a condition of redress is a complete release of any common law rights, it's your experience that it's meaningless because nothing's being released.
I think that's right, but a release is likely to dissuade the victim from embarking upon what might be futile litigation. So there is a benefit to both the victim and the proposed defendant that expense and angst isn't undertaken. Now, I'm not saying that's the reason for the release,
No.
but I'm just responding to what Your Honour asked.
Now, you know there's discussion before the Royal Commission about the possibility of changing the civil liability rules.
Yes.
One of the clearest ones has come from the Victorian inquiry, create a vehicle that can be sued. Do you think it's fair to people to say, here's a generous redress scheme, but the price of accepting it is to forgo your common law rights for all time?
I'm reluctant to answer that, Your Honour, because of my position as chair of the panel. I'm conscious of the people who have come before the panel while I chair it and the people who will come in the future. But as a lawyer, and this is a private view, I can understand that argument.
Well, you know that the Sydney Archdiocese doesn't seek a release.
Yes.
And the expectation would be that if compensation has been provided but a common law claim succeeded, then there'd be an adjustment of the claim.
Yes.
Isn't that right?
That's not unusual. It's true of work cover. It's true of all sorts of non-liability schemes.
It's the way fairness would operate. Yes, very.
In relation to the example you gave, arising from the Four Corners, were you seeking to say that the discussion was about whether the church would provide a lawyer as opposed to provide funding for a lawyer of the complainant's choice?
I meant provide funding for a lawyer.
Thank you.
I wouldn't ever seek that a lawyer be imposed on someone else. The person who consults a lawyer should go to the lawyer of that person's choice.
Yeah, it's just the wording you used, Mr.
I'm sorry about that.
Suggested the alternative. Now, can I just indicate that in order to be fair to the person that we're discussing, a copy of the transcript of your evidence in respect of that will be provided to her.
I'm perfectly comfortable with that.
And should we need to take it further, we'll be in touch with
Yes.
you, Mr. Gleeson. Now, I'm sorry, Mr. Curtin, I beg your pardon. Perhaps if we can have tab 258 on the screen. Now, this may have been brought to your attention or not, Mr. Curtin. This is the claim summary from CCI in relation to a particular person. If we can just keep it where it is now, don't scroll down. Go, thank you. Do you have any involvement with the Catholic Church Insurance in the course of your work as chair?
Not at all. Absolutely none.
Do you have any understanding as to who pays for whatever award is made following your recommendation?
I've never inquired and I don't have any real knowledge of it at all.
Thank you. Now, if we can just scroll up, this is in relation to Mr Hurstback, who appeared before, or who was before your compensation panel in, I think, 2006 or thereabouts.
Yes.
Do you recall that event?
Not really.
No.
And I apologise for that. It's
No.
partly age, partly time.
But you don't doubt that you were the chair of the
No,
panel?
I remember the name
Yes.
and I remember dealing with a number of victims of Father Rubeo.
Thank you. Now, if we can just read what's on the screen in respect of investigation, if you just read that to yourself.
Yes. Yep. Can I just see the top of this document again, please?
Certainly. Would you like a hard copy, Mr.
No,
Curtin?
it's okay. Yep. Thank you.
Now, have you finished that reading?
Yes,
that
I have.
You see there that the panel awarded $17,500.
Yes.
Now, this document was authored by a senior person within CCI, Mr. Rolls. You haven't come across him?
Not that I know of.
And he reflects his view of the panel recommendation. And then if we go under the heading Other Relevant Information, if we stop there, if you can read that to yourself.
Yes. Yes.
And then if we can go to the next page. And just stopping after you've read the first paragraph.
Yes, I've done that.
Now, he states the opinion that there are very seldom independent medical reports and the insurers rely upon CareLink, who appear more than ready to attribute the ailments with which the claimant presents to the alleged abuse. Now, just stopping there, the medical reports that you receive as part of your work can come from CareLink or be authored by someone related to CareLink?
I think it's more accurate to say they're commissioned by CareLink. CareLink will arrange for the victim to be assessed by an independent psychiatrist. There have been one or two. You've no doubt seen Dr Susan Brand's reports.
Yes.
She provides most of the reports that we see. And
Now-
she does a very good job. She's thorough and analytical.
Now, you see the opinion expressed there that the medical reports appear more than ready to attribute the ailments with which the claimant presents to the alleged abuse. Now, is that a matter that you share the author's opinion?
No, that sounds to me like an insurance person's view about most claims.
You've indicated, I think, earlier that in the event that, and you'll have to help me here, Mr. Curtin, that there was one cause in respect of the presenting position, it was accepted that the abuse was a cause of...
Yes, if some people have got multifactorial issues resulting in a condition, at common law, if the tort is a cause, in this case if the assault is a cause, then the victim is entitled to compensation, we say, for the full amount up to the cap.
And in determining whether there is a cause, do you primarily rely upon the opinions expressed in the medical reports, or do you consider it more a question of fact for you to determine?
It's usually the medical report, because the medical report details the person's psychiatric history. But that's not to say we wouldn't have used our own appreciation of the victim by meeting him or her face to face.
Can you recall an occasion where you, as a matter of fact, drew a different opinion from that expressed in the medical report as to cause?
No. And I can't recall one where we hadn't attributed the offensive behaviour as a cause to a victim's condition.
Thank you. Thank you. Mr Curtin, I have nothing further.
No question, thank you. No question, John. No one else?
Yes, Your Honour, just a couple. My name is Mr Woods. I appear on behalf of Mr Curtin. Mr Curtin, you were asked some questions by counsel assisting in relation to the victim's ability to talk about the abuse and the payment that's made to them following their engagement with the compensation panel. There's a form that was shown to you, and if that could be brought up at tab 271. As I understood your evidence, you're aware that Mr Leader's given evidence about the imperfections of this form, and I understood your evidence to be supportive of those comments. In any event, Mr Leader later explained that the form should be amended, and there's another document that he referred to in his evidence, and I'd like to bring that up on the screen now, and that's at tab 285. In your statement, you say to victims who engage with the compensation panel that they're free to shout it from the rooftops in relation to the abuse and the amount of payment that they receive. Mr Leader gave evidence that this document here, and if I could be scroll down to the bottom of page 1, please, is, if I could paraphrase, a more effective pronouncement of the victim's rights in relation to talking about the abuse that they've suffered and talking about the payments that they've been offered under your process. Do you agree that this accords with what you explain to victims when they approach the compensation panel?
Yes, could you?
So I'm talking about the...
Yes, I agree with the second last paragraph. I'd like to see the top of the next paragraph because there's something they're asked to keep. If you could scroll down the page to the next page. Yes, I agree with that. That reflects what we tell the victims.
Yes.
And that's, I must say, it'd be more felicitously expressed in the application form if it was redrawn, I hope.
And you were asked some questions about the amount of compensation payments, and you talked at the beginning of your evidence about your what I'll characterise as significant experience in the common law of 30 years or so. Is it correct to say that when a judge is deciding an amount of compensation to be paid for a victim, and they're specifically looking at the head of damage for past and future medical costs, that the judge will have to do her very best to determine what those costs might be into the future?
Yes.
And is it correct to say that a part of the Melbourne response that you're not a part of, but I'm sure you're aware of, being CareLink, does not cap those medical costs so far as they're related to the abuse?
Yes, I tell the victims that some of them are already having counselling, and I say to them, I would like you to consider counselling. I say, I've got no experience in this field, but many victims find it beneficial. I'm not suggesting you should have counselling, but all I do is ask that you consider it because it's certainly worthwhile considering. And I say, if you do decide to have counselling, it will not be dependent on your accepting an offer or not, but it will continue as long as it's of benefit to you. And I say to them, you don't have to have the counsellor that is recommended for you. You should change the one if you're not comfortable with it.
And if tab 271 could be brought up once more, just a final issue. In relation to, you've given some evidence about what you tell victims about their ability to seek legal advice or otherwise. The top of what I've described as an imperfect form that is due to be updated, at page 2 of that form, I'll just take you to the words completion of the form will affect the applicant's legal rights and applicants are encouraged to seek legal advice before completing the application. And to your knowledge, is that a phrase that's been in that form during your chairmanship of the panel?
I expect so.
Thank you, Mr Curtin. Nothing further.
No one else? Ms Finnis?
Nothing further, Your Honour, thank you.
Yes, thank you. Thank you for
Thank
coming.
you, Your Honour. Thank you.
You're excused.
It may be that Mr Curtin might be needed again, but we'll be in touch if that occurs.
I'm sure he'll be capable of being on.
Not going anywhere.
Yes, thank you.
Thank you.
Your Honour, Mr Curtin is the final witness today. On Monday, we propose to call first Ms Sharkey, who is involved with CareLink, followed by Mr Francis Moore, who's the business manager for the Archdiocese, and then we've indicated to those representing the Archdiocese, although not apparently the Archbishop, that the Archbishop will need to be available at 2 p.m.
So we'll adjourn until 10 o'clock on Monday.
Thank you.